seated.
Thank you, Your Honor. We're present in the matter of State of Ohio versus Jaden Foster, case number 25CR001291. The defendant is present in court with defense counsel Chad Mulkey. We are here for purposes of a change of plea hearing. The defendant was indicted with a one-count indictment on November 21st, 2025, that one count being counterfeiting, a felony of the 4th degree, in violation of revised code section 2913.30B2. All discovery has been provided to defense at this time, and at the pretrial, a offer was made that the defendant plead to an amended count 1, attempted counterfeiting, a felony of the 5th degree. It is my understanding that today the defendant wishes to accept that offer, withdraw his previously entered plea of not guilty, and enter a plea of guilty to an amended count 1, attempted counterfeiting, a felony of the 4th degree in violation of revised code sections 2923.02 and 2913.30B2. Thank you.
All right, Mr. Mulkey.
Thank you, Your Honor. That is all accurate. I went over the plea paperwork with my client. He indicated he desires to go forward with that change of plea today. I did explain to him that he will have to go over to the probation department for a pre-sentence report, assuming that plea is accepted. He indicated that he may test positive for marijuana today.
Mr. Foster, how old are you?
I'm 20, sir.
How far did you go through school?
I graduated high school.
Are you a U.S. citizen?
Yes, sir.
Are you able to read, write, and understand the English language?
Yes, sir.
Prior to coming to court, have you taken any drugs or alcohol or any prescription medication within the last 48 hours?
No, sir.
Pardon?
I said no, sir.
Have you ever been diagnosed with or treated for any mental illness?
No, sir.
Did you get a copy of the indictment filed in this case?
Yes, sir.
It's my understanding you're going to plead guilty to the lesser included offense in the indictment, that is attempted counterfeiting, a felony of the 5th degree. Is that your understanding?
Yes, it is.
Before I accept your guilty plea, I need to determine that you know and understand the constitutional rights you'll be waiving, the consequences of your guilty plea, and the maximum penalty I could give you. And I need to be satisfied that your guilty plea is being made freely, knowingly, and voluntarily. I'm going to ask you questions. If you don't understand a question, stop me. If you want to talk to Mr. Mulkey some more, let me know, and I'll give you more time. Do you understand that?
Yes, sir.
You have a constitutional right to have a trial, either to me or to a jury of 12 Lake County citizens. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to a jury trial, all 12 members must agree to a guilty verdict before you can be found guilty. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, the prosecutor will call witnesses to testify against you. Do you understand the prosecutor must prove you guilty beyond a reasonable doubt at a trial?
Yes.
After the witnesses are done testifying for the prosecutor, you have the constitutional right to have your lawyer cross-examine the witnesses. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you go to trial, you have the right to have witnesses come here and testify for you. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If those witnesses refuse to come to court, I'll issue an order called a subpoena to make them come and testify. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the right to testify at trial if you want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
You have the constitutional right to not testify at trial if you do not want to. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you decide not to testify at trial, nobody is permitted to comment on that decision. Do you understand that?
Yes, sir.
If you go to trial and you're found guilty, you have the right to appeal the guilty finding. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you file an appeal, you have the constitutional right to have a lawyer represent you in that appeal. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to hire a lawyer, one will be provided at no cost to you. Do you understand that?
Yes, sir.
If you file an appeal, you're entitled to be given a transcript of all the hearings in this case. Do you understand that right?
Yes, sir.
Are you waiving that right?
Yes, sir.
If you could not afford to copy those transcripts, they'd be given to you at no cost. Do you understand that?
Yes, sir.
If you plead guilty today, you will not have the right to appeal the guilty finding. Do you understand that?
Yes, sir.
Do you have any questions about any of these rights?
No, sir.
Do you still want to plead guilty to this charge?
Yes, sir.
You understand by pleading guilty, you're fully admitting your guilt to the charge.
Yes, I do.
Do you understand by pleading guilty to this felony, you're voluntarily giving up your freedom for whatever period of time I could sentence you to prison, to jail, or to community control?
Yes, I understand.
The attempted counterfeiting is a felony of the 5th degree. It carries a 12-month maximum prison sentence and a $2,500 maximum fine. Do you understand that?
Yes, sir.
Are you presently on post-release control to the parole authority?
Are you on parole?
Oh, no.
Do you understand that if a prison term is imposed in this case, you might have to serve a period of post-release control for up to 2 years under the parole authority?
Yes, I understand.
If you are placed on post-release control and violate any conditions, the parole authority could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. Do you understand that?
Yes, I do.
If that violation of post-release control is a new felony, you could get an additional consecutive prison sentence for the violation. Do you understand that?
Yes, I do.
And if that were to occur, the maximum prison sentence for the violation would be the greater of 12 months or the time left under post-release control. Do you understand that?
Yes, sir.
Do you understand that if a prison term is imposed, you are eligible for judicial release?
Yes, sir.
I could place you on community control for up to 5 years, but if you violate any conditions, I could send you to prison for 12 months. Do you understand that?
Yes, sir.
Has anybody promised you that I would be lenient on you just because you're pleading guilty today?
No.
Has anybody promised you what I will sentence you to in this case?
No.
Do you understand I do not have to follow a sentencing recommendation of either the prosecutor or your lawyer?
Yes, I understand.
Have you had enough time to talk to Mr. Mulkey before pleading guilty today?
Yes, I have.
Has he discussed everything about your case and answered all of your questions?
Yes, he has.
Are you satisfied with the advice he has given you?
Yes, I am.
Have you been threatened or coerced in any way to plead guilty today?
No, I have not.
Are you freely, knowingly, and voluntarily entering your guilty plea?
Yes, I am.
Do you have any questions?
No, sir.
All right, Ms. Horanik, if the case went to trial, what would the evidence show?
Thank you, Your Honor. Had this case proceeded to trial, the state would have proven beyond a reasonable doubt that on August 26, 2025, in Willowick, Lake County, Ohio, the defendant did attempt to commit the crime of counterfeiting, which is defined as purpose to defraud or knowing he's facilitating a fraud, pass, utter, sell, purchase, conceal, or transfer any counterfeit obligation. Specifically on that date, the defendant was driving a vehicle that was going through the drive-thru at the McDonald's in the city of Willowick. The defendant placed an order and handed a counterfeit $20 bill to the cashier in an attempt to pay for the order. The defendant then drove away before anything further could be done. However, the counterfeit $20 bill was retained by McDonald's and was found to contain stamps on it that stated replica and for motion picture use only. Thank you.
Mr. Mulkey, anything to add to those facts?
No, Your Honor.
Mr. Foster, did you hear what Ms. Horanik said, that the facts would show if the case went to a trial?
Yes.
Are those facts true?
Yes.
All right, what is your plea to the lesser included offense of attempted counterfeiting, a felony of the 5th degree?
Guilty.
Mr. Mulkey?
Thank you, Judge. This is what we went over in the hallway. Go ahead and sign it there. And then you can date it 1/29/26.
And for the record, I've witnessed the defendant and defense counsel sign the written plea of guilty in open court. I have signed the same document, and I'm now handing it back to the court.
Mr. Foster, is this your signature on the written plea of guilty?
Yes.
Did you sign it voluntarily?
Yes.
Do you want me to accept your written plea of guilty?
Yes, I would like to.
All right, I'll accept the written plea of guilty. Defendant is present with Mr. Mulkey, advised of all of his rights, being a knowing, intelligent, voluntary waiver. He understands the nature of the charge, the consequence of his guilty plea, and the maximum penalty. Find it to be knowing, intelligent, and voluntary. I will accept his plea of guilty. Find him guilty of the lesser included offense of attempted counterfeiting, a felony 5. I'll refer this for a pre-sentence report. Sentencing will be February 25, 3:15 p.m. The bond is continued. Anything else, Ms. Hronik?
No, Your Honor, thank you.
Mr. Mulkey?
No, Your Honor.
All right, we're adjourned.
Counselor, I'll send over the paperwork here in a second.
All right.
Seated, please. Ladies and gentlemen, do you have a verdict?
Yes, Your Honor.
Would you hand that to, All right, in the case caption, State of Ohio versus David L. Post Jr., 25 CR 419, count 1, felonious assault. We, the jury, being duly impaneled and sworn, find the defendant David L. Post Jr. guilty of felonious assault as charged in the indictment. Signed January 29, 2026, signed by all 12 jurors. First, firearm specification to count 1. We, the jury, find that the state did prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of felonious assault. Dated 1/29/2026, signed by all 12 jurors. Second, firearm specification to count 1. We, the jury, find the state did prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense and used the firearm to facilitate the commission of the offense. Dated 1/29/26, signed by all 12 jurors. Forfeiture specification to count 1. We, the jury, find the state of Ohio did prove by clear and convincing evidence that the Ruger LCP Max pistol is subject to forfeiture to the state of Ohio. We, the jury, find the state of Ohio did prove by clear and convincing evidence that the magazine is subject to forfeiture to the state of Ohio. We, the jury, find the state of Ohio did prove by clear and convincing evidence that the ammunition is subject to forfeiture to the state of Ohio. Dated 1/29/26, signed by all 12 jurors. Count 2, felonious assault. We, the jury, being duly impaneled and sworn, find the defendant David L. Post Jr. guilty of felonious assault as charged in the indictment. Dated 1/29/26, signed by all 12 jurors. First, firearm specification to count 2. We, the jury, find the state did prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense of felonious assault. Dated 1/29/26, signed by all 12 jurors. Second, firearm specification to count 2. We, the jury, find the state did prove beyond a reasonable doubt that the defendant had a firearm on or about his person or under his control while committing the offense and used the firearm to facilitate the commission of the offense. Dated 1/29/26, signed by all 12 jurors. Forfeiture specification to count 2. We, the jury, find the state of Ohio did prove by clear and convincing evidence that the Ruger LCP Max pistol is subject to forfeiture to the state of Ohio. We, the jury, find the state of Ohio did prove by clear and convincing evidence that the magazine is subject to forfeiture to the state of Ohio. We, the jury, find the state of Ohio did prove by clear and convincing evidence that the ammunition is subject to forfeiture to the state of Ohio. Dated 1/29/26, signed by all 12 jurors. Does either side wish to have the jury polled?
Yes, Your Honor.
All right, ladies and gentlemen, I will call out your juror number and ask you if this is your verdict, and you can respond. Juror number 1, is this your verdict?
Yes, it is.
Juror number 2, is this your verdict?
Yes, it is.
Juror number 3, is this your verdict?
Yes.
Juror number 4, is this your verdict?
Yes.
Juror number 5, is this your verdict?
Yes, Your Honor.
Juror number 6, is this your verdict? Juror number 7, is this your verdict?
Yes.
Juror number 8, is this your verdict?
Yes, it is.
Juror number 9, is this your verdict?
Yes.
Juror number, 8, is that your verdict?
8.
8, 9, okay. On juror number 10, is this your verdict?
Yes.
Juror number 11, is this your verdict?
Yes.
And juror number 13, is this your verdict?
Yes.
All right, thank you very much, ladies and gentlemen. You can excuse yourself to the jury room. I'll be in to talk to you in a little bit. Thank you very much for your service.
All right, so jury.
right, have a seat. All right, I'm going to refer this to the Adult Probation Department for a pre-sentence report and a victim impact statement, and the bond is going to be revoked. Anything further from the state,
No, thank you, Your
from
Honor.
the defense?
No, Your Honor.
All right, we're adjourned.
All rise.
Sir, you tell him to stand up. Custody right now, that's what you have anything on you that you want to give to your family right now? No.
No.
All right, go ahead and place your hands on your back. Put your hands together. We'll come see you. Here, man. You okay?
No.
What's wrong?
I feel like passing out right
Okay,
now.
sit down for a second. Sit down for a second. Sit down. Cuff you on the front here, all right? How you feeling now? You feeling all right?
Blackout.
If you can just give him a second, he's got.
Yeah, I will. No problem.
You want some water or anything, Dave?
Yeah, if you got some. Great.
You all right?
Yeah, let's go.
All right, man. We gotta turn it this way. We'll take our time, all right?